Well, I think one of the first important aspects is that in the US, the concept of employment at will is recognized, which in short means that either the employee or the employer can terminate that relationship at any time, with or without notice, and for any reason or no reason. So that's the first concept of a huge difference between the US and Denmark. Second issue is the different layers of legal regulation of the workplace that you find in the US. It's not just a single national law that applies equally all over, and that's the sole source of regulation. In comparison, the US has a federal statute, a state statute, a county statute, a city statute, and employers really need to ascertain what are the obligations imposed by these various levels of laws. The third important difference is, in the absence of protection against unfair dismissal law, under the rubric of the employment at will doctrine, employees who are terminated will couch an employment dispute as a discrimination claim. Employees will come up and formulate some kind of protected category that they claim was the reason for their termination. And what that does is it really makes it difficult for employers frequently to anticipate their potential exposure. Furthermore, discrimination claims are not heard by specialized tribunals like a labor court in Denmark. They go to regular civil courts, and surprise, they are heard by juries. So all fact issues are heard by juries, which makes it very difficult to predict the outcome of a case, how a jury will rule on it. Hand in hand with that are the tendencies of juries, if they side on the side of the employee, to grant substantial damage and punitive damage awards. It's not unheard of in a single dismissal where an employee will be awarded a few $1,000,000 in compensation. Lastly, among all these layers of laws that apply to the workplace, some impose significant obligations on employers. To name a few, policy development is important in the US. So employers must have good employee handbooks with policies. On the policy front, various state laws, for example, Connecticut, will require that employers have policies. Second, certain states, an example, California, will require that employers actually train employees on certain policies. If you fail to do that, you may be liable for civil penalties. So the US workplace legal structure is, I think, slightly more complex than in Denmark, and it's important for employers moving into that market to fully understand all these layers as well as the different obligations that it imposes.